Savelin Sochirca found his neighbor's dog Millie in his chicken coop. He retrieved his BB gun and put dozens of BBs into Millie's head, including her eyes. He left the dog, expecting her to pass, but when he returned, she was still breathing. He led her out of the coop and left her lying in the snow. Millie's owner, Chris, noticed the dog was missing and followed her tracks to Sochirca's home. Sochirca took him to Millie, who was bleeding but miraculously still alive. Chris rushed her to the vet where she was treated, and at least 40 BBs were removed from her head. She survived but was left blind. Sochirca was found guilty of first-degree animal cruelty. He is now appealing his conviction, arguing the trial court erred when granting his request to represent himself and by ignoring his right to injure a dog attacking his livestock. Let's take a look at the arguments.
Jean-Luc McCain, appearing on behalf of Savelin Sochirca, the appellant in this case. We are asking the court to reverse his conviction for animal cruelty in the first degree for two reasons, one of two reasons, either or both. Improvident and unconstitutional dismissal of counsel, denial of standby counsel, and improvident authorization allowing him to proceed pro se. And the other is the improper finding of guilt on the animal cruelty statute when he was subject to the statutory defense of defending his animals. State v. Acre requires that, well, the cases are clear, the standard is clear, unequivocal request. Now this is waiver of counsel. Unequivocal request, a knowing choice, an intelligent decision. However, in applications, those are not quite so clearly defined. I am going to address the knowing choice aspect of that because therein lies, in this case, based on the facts, a reversible error. As counsel points out, a lot of the decisions of the trial court are discretionary, but this, the knowing choice is subject to reversible error if not satisfied. So State versus Acre requires the record must reflect that the defendant understood the seriousness of the charge, possible maximum penalty, and the existence of technical procedural rules governing the presentation of his case. In this case, there was a colloquy. It was rather short and simple and did not address the seriousness of the charge, did not address possible penalties.
What about at the arraignment? A defendant is arraigned and told of what he's charged with, including the maximum penalties. Is it your position that that's insufficient?
Yes. Number one, that's not in the record. There's nothing in the record here. Number two, so we don't know what happened there. And the assumption is that that was done. But another aspect is that if that is sufficient, the judge would never have to address that with the defendant. And beyond that,
well,
again,
I think that the standard requires that the defendant know these things. Mm-hmm. And so I guess the question is, does the record allow the state to establish that the defendant knew these things?
That does not establish that the defendant knew these things or appreciated these things. Because, yeah, that's the standard, that the defendant understood and appreciated. And to say that it is in the record somewhere, arraignment, probably was a long time ago, does not establish that the defendant knew or understood. There's a case out of 3rd District, 3rd Circuit, that states very clearly, in that case, the argument was, well, there was a pre-sentence report in a companion case that laid out the sentence, the maximums and the sentencing system, and the court said, we cannot assume that the defendant read that. We cannot assume that the defense attorney explained that to him. It just sitting there, as a matter of fact, does not satisfy the knowing prong. So That is the only thing in this case, and it isn't in the record before you. State versus Silva. Held 2001 to one case held that a colloquy that failed to include the critical information concerning the nature of the charges and the maximum penalties was constitutionally defective, and held that failure to warn the defendant of the risks associated with preparing for trial by jury made the waiver invalid. And court held that deprivation of the right to counsel is so inconsistent with the right to a fair trial that can never be treated as harmless error. And that's where we get the reversible error. That's where we move beyond abuse of discretion.
I do have one question going back to the knowing choice that you were focused on earlier. With respect to him being aware, your client being aware of the seriousness of the charge and the consequences, the maximum penalties, how much time had taken place between when he was arraigned and when he decided that he wanted to represent himself, or when the court allowed him to represent himself?
Well, I have it, but I wasn't trial counsel, so I don't have that.
Are we talking about weeks? Are we talking about days, or what are we talking about?
Weeks, several weeks.
Okay.
This happened at a pretrial conference, and there had already been prior hearings. So yeah, it was a ways down the line.
Might that be one of the reasons why most judges at least are taught to put on the record contemporaneous when they're analyzing these issues, a number of these factors, including the seriousness of the charge? Correct.
Yeah. And I would add in there, it should be obvious from the record, this man is of limited intellect and very limited. And that was not developed because he was representing himself. But, and I will say at this point, there is a companion appeal that we were not successful in joining because apparently I waited too long to make the motion. But there is another one, a post-conviction motion appeal in which that factual background is developed. It's not in the record before us other than what's just apparent in what's there. So, yeah, you can't assume that because it appeared in the record sometime in the past that the defendant either knows or understands or appreciates it.
Or at least at the time he chose to waive his right, there has to be established that he knew and he understood this. And so what you're saying is that if this was something that was told him several weeks ago, then it's a bit of a leap that he still understands it.
Right. That's the standard. That's the language. And a lot of cases do go back in the record to find that the defendant knew and understood, but it takes more than the fact that it occurred at the beginning at an arraignment or appeared in a pre-sentence report in a companion case. It takes more than that. It takes apprehension and appreciation. So Silva, I think, is the seminal case here. And to be honest with you, I missed that on my first time around. I since have a better research platform. I was using the Bar Association's free one. I'll make that comment. So to address the state's response, they raised the fact that it was stated in the charging information, but we don't have that record. We don't have anything about that other than we presume that happened. And their assertion that Mr. Sochirca's counsel must have explained these things to him. Again, that's speculation. There's no citation to the record for these things because there is no record of these things.
I'll be quite honest here. I think I recall when I read the state's brief that it cited to the record when it made this representation. I didn't look at the record itself, but I assume it's there in the record. So I will listen to what Mr. McCrae says. I didn't catch whether it's actually there or not because I didn't look, but I do know that you did provide a cite for that.
I did read the record, and there is a first appearance where the information was read, and there's also an arraignment where there's a discussion about the maximum as well as it being an unranked felony, and there's some discussion.
Well, if that's true, I didn't have it to work with because I was trying to chase that down.
Okay, well, it's there, so we've crossed that one off at least.
Okay. If that was sufficient, again, I think I made this point, but if that were sufficient to satisfy the case requirements, it'd never have to be done. We just say, hey, you were arraigned. We read that to you. Charging information said it. You should have read it. I don't think that's the rule. I don't think that's adequate. That doesn't show an appreciation or understanding.
I don't want to get you off topic too much, but your time's getting down there. We're under 5 minutes. I have a question about the defense and the justification for an animal. In a self-defense case, the defendant would have to admit the assault in order to invoke self-defense. You can't say I didn't assault this person, but if I did, it was a self-defense. Here, the defendant said, or the appellant said, that it was his son Vincent who shot the dog. If that's his defense, I didn't shoot the dog, how can he then invoke the justification of killing it or attempting to kill it because it was chasing his poultry?
Well, the court found that he did, and he claimed he did. He gave two statements saying that he did, and I guess I'm not familiar with a waiver of that, of alternate defenses.
Wouldn't the defendant have to say, I killed the dog, and I killed the dog because it was harassing my poultry? If he says I didn't kill the dog, he's denying that he would have done it in defense of his poultry. So they're mutually exclusive from one another, much like self-defense. Wouldn't that be the case?
Well, he gave two different stories, yes. And he was convicted on, well, he gave three. He was convicted on the first two. And the finding of fact was that he shot the dog. And according to that set of facts, he intended to kill it. He was defending his chickens, and he thought that it was dead, or else, yeah, he was surprised that it was not dead, thought it had died, went back, it was still alive, and it wasn't quite dead. But everyone admits that it would have died if it had not been saved.
Well, going back to the statute here, it says that basically that a person may not torture an animal except as authorized by law. And that's a very general paraphrase, a bad paraphrase, but that's generally what it says. Except as authorized by law, a person may not torture an animal. Where does the law allow an animal to be tortured? I don't think it does it?
The torture is the mental state. It is the legal status. And that, so the state is arguing social norms. What are they? Where's that standard? There's no standard if it's social norms. Our position is when you're defending your animal, you are not subject to the animal cruelty. If you are maliciously, intentionally, with no legal justification, inflicting injury and pain and suffering to an animal, that is animal cruelty. But if that is not your intention or your purpose or your legal status, you're not subject to that statute. And that's because it's a social issue here, and we know we've got people on both sides of that. In fact, that's what the state argues. There are people who would say this. So that is the legal line, the definition. Otherwise, we're dealing with social norms and people's emotions, and that's really what we're dealing with here.
You're into your rebuttal time right now. I'm not sure if you want to reserve the rest.
I will.
Okay, very good. Mr. McCrae? One of the first questions I'd like to know is what the time difference is between when the person was last advised of the seriousness of the offense and when he asked to represent himself.
I don't have the specific time. I would agree was on probably the order of a couple of months.
Couple of months. Okay.
Again, I have to look at the record
Okay.
to be
We
sure.
can find that out.
But
we can find that out.
That's probably about right. The defense attorney had brought a motion to dismiss fairly quickly, and it was after that, so there was time for that process to happen.
Okay.
So exactly when I'd have to look at the
We can
record.
find that out. Okay,
Yes.
thank you.
For the record, Kevin McRae, representing the state of Washington, Grant County Prosecuting Attorney. And the knowing, intelligent, and voluntary is, I think, based on the entirety of the record. And Mr. Sochirca was very insistent on representing himself. Matter of fact, the judge saw him struggling and said, "Please let me appoint you an attorney." And he said, "Absolutely not."
Well, it may be a little overstatement, but the judge did see the defendant struggling and offered again, "Would you like me to appoint an attorney for you?" And
Yes.
it was clear he said no.
So I don't think there's anything ambivalent or impressive. And I mean, this is a court case. It's clearly a felony, very serious case that we were going through. Could the colloquy have been a little bit more expressive? Yes, absolutely. I would agree with that. But it was sufficient under the case law to meet the requirement. And Mr. Sochirca was very clear. He did not want an attorney.
One question I've got here, following up on my initial set of questions. I'm somewhat concerned about the length of time between when he was advised of the consequences of or the punishment and when he decided to waive the attorney, waive his right to an attorney. There does have to be a showing that the defendant understood the consequences of being found guilty, basically. Isn't it true that the longer of time between the event of when he was told about the seriousness of the offense and when he waived his right, that perhaps it's more difficult to establish that he was aware of the seriousness of the offense?
That would be one factor. I would agree. Yeah. But now we're getting into evidentiary weighing and all that kind of stuff. Right. And it is a abuse of discretion standard. Okay. And so I think that kind of goes towards the trial court. And I would agree that
the trial court made a finding.
And, I would agree that should be a consideration, but I don't think it's determinative.
Okay.
Mr. McRae, what is the minimum requirement for a colloquy to meet the knowing, intelligent, and voluntary standard? What information needs to be exchanged for the court to come to that conclusion that the defendant is making a knowing decision?
It has to be clear and unequivocal. I think that's very clear in the case law. His request is clear and unequivocal. He has to have an understanding, but there's no magic words of that, hey, this is serious. This is the potential effect on your life, or at least a vague understanding of being precise is probably not possible. But and that there is a significant risk in representing yourself. And that,
So the colloquy that's on the record here, it's clear that the trial court told Mr. Sochirca that he would need to follow the rules of evidence, file motions, be responsible for the case, would have to act as an attorney would not receive standby counsel, indicated the law required the trial judge to state to the defendant that he would be better off with counsel, and then confirmed he was not being coerced. Is that a sufficient standalone record for a waiver?
I think it's close. And then when you add in this is serious and these are the potential consequences.
Well, that didn't happen at the colloquy.
Not at the colloquy, no, that's in the record elsewhere, but it didn't happen in the colloquy.
Is there a case where any court has found a colloquy was sufficient by utilizing information exchanged at hearings outside of when the colloquy occurred?
I did not find a case that answered that question either way. I didn't find a case that said no. I didn't find a case that said yes.
You would fall back though on your previous answer that there was a finding of knowing, intelligent, voluntary.
And it's an abuse of discretion.
But at the same point, from a policy perspective, there's some concerns we may have on bootstrapping prior hearings when it's just as easy for a trial court to do it right. In other words, we don't want to perhaps set precedent for it's okay if you don't do it right, just don't do it again. That's not a very good rule.
Well, we have a lot of that precedent. It's called harmless error, which is kind of like you didn't do it right, but we got to the correct result.
Oh, and it's constitutional. It's harmless beyond a reasonable doubt.
Yeah, it's true enough, but we do have that kind of philosophy.
Is it the state's position, excuse me, that a later offer to reappoint counsel can cure a defective colloquy?
I think it depends on the part of the colloquy. You know, one of the things that defense raised was this was a not clear request. And I think that it definitely clears it up when the judge comes back and says, I want to give you an attorney. And he says, no, in no uncertain terms. I think that definitely clears up that issue.
So let's assume that the court can find there was an adequate colloquy on whether it was voluntary and that it was unequivocal. What do you point to demonstrate that it was knowing and intelligent? What exchange of information between Mr. Sochirca and the court during that colloquy would make it a no? I understand the trial court made that conclusion that his waiver was knowing and intelligent, but looking beyond that, what is that based on?
Based on the descriptions that the court gave him of, hey, here's what you'd have to do. Do you understand this? Yes, I still want to represent myself. I think that is where you look to. That's why we have those, he was told you're going to have to follow the rules of evidence. You're going to have to file motions, that kind of stuff. I think that's what those go to, is where we would look at. Unless there's any further questions on that, I'm about halfway through my time, so I'll kind of switch to the other topic unless the court has any more further questions.
I do think that first topic is where the court is struggling.
Okay.
I don't know if we have any further questions. This is.
I guess I do have one.
Yeah, please,
thank you, Chief.
please.
Mr. McRae, is whatever the minimum colloquy is, should it be heightened when we have a person who has a language barrier?
Mr. Sochirca had an interpreter during this whole thing. I understand there's debate as to how good that interpreter was, but the court found that it was good and adequate. And so I think that no, it should not be heightened because you have, it's kind of funny we call this knowing and intelligent. Well, we all know that that representing yourself probably isn't intelligent in the common sense of that term. And we have to be careful that we're not placing we're not denying somebody their Faretta rights because they don't communicate as well. You've got that balance there. And so I think we have to be careful about saying, okay, you have an extra burden to establish your Faretta rights that somebody who speaks perfect English would not. And I think, so you got to balance those two things.
Is there a difference in allowing someone to proceed without an attorney who has been represented by an attorney for a period of time and then chooses not to be, versus someone like in State versus Chavez, where they never had an attorney and just kind of summarily chose to go without an attorney? Is there a different standard based on what they might have experienced?
Given that it's a whole factual, it's a totality of the circumstances thing, I think a little bit, yes, that is one of the circumstances. He saw what an attorney could do for him. He saw what an attorney would do for him and still decided he didn't want to go down that path. So I think it's part of the totality of circumstances. Yeah, I think it does matter.
At least you might be able to argue that he had a better understanding of the process. Especially if this was his first time ever arrested. And I don't know what the criminal history is. I didn't look at it, but
not much. As
yeah.
far as I know, this is the first time through the system.
Yeah, this isn't a frequent flyer.
Right.
This is a U.S. constitutional standard, or is a state standard?
I have not seen any case law that says the state standard is higher than the U.S. constitutional standard. Right. And I don't think I saw any gun law analysis arguing otherwise. Right. I'm just surprised that we don't have a case throughout the country that has a situation here where someone had to rely upon to prove that it's knowing, to go to a different hearing. I'm just surprised that we don't have any case law on that. No. Right. Okay. Don't have a great answer for that. And just to briefly touch on, unless there's anything else on that topic, just to briefly touch on the other topic, we've agreed from the get-go that Mr. Sochirca had every right to kill Millie. There's no real question about that. What he didn't have the right to do is torture her. And there's tons of reasons why people kill animals.
Back you up
Sure.
on there. Is there, the statute, I think, probably is very poorly worded. Would you agree with me that there is no lawful or legal ability to torture an animal? It says except as authorized by law.
Right.
Yeah, and so there is no law that authorizes torture.
No.
And so one can almost read that exception out of it right there.
Yes. I mean, there's nothing that says, you can experiment on animals, and there's a specific statute for that. And you can even kill them in support of those experiments, but you can't torture them. And that's what happened here is.
That goes to intent though, doesn't it? I mean, the intent, the outcome may be harm, maybe pain if a hunter makes an errant shot,
Right.
attempting to make a clean kill and they don't. The intent was the kill, not the torture. The same with the scientific experiment. Isn't really, it's the intent, the focus, not the outcome?
Not quite. It's by the statute, it's the knowledge that's the focus. I believe it's knowing, not intentional. And so here, Mr. Sochirca, even if he didn't intend it, knew what he was doing was causing extreme pain and harm and suffering. And so I think using the intent, usually intent and knowledge go hand in hand, but there are some places where it's different. And I think this is one of them, where he knew when he dragged Millie out into the snow that was going to cause extreme suffering. At least from the circumstances, you can infer that knowledge.
And that also infers shooting a dog 40 times in the head with BB, including in the eyes.
Is going to cause, right. Now, that may not have been his ultimate intent, but he certainly did that knowing that would be the result. I think under the statute, the difference between intent and knowing is important.
Any further questions? Okay, Mr. McKean, you've got a little over a minute. I believe I'm wrong. It says, yeah, there we go, a little over a minute.
The time when he was struggling and the judge said, do you want me to appoint an attorney? The judge should have appointed the attorney. Because in that same page of transcript, Mr. Sochirca said 3 times, they were talking about scheduling an omnibus hearing. 3 times he said, I don't understand. What are you talking? I don't understand. 3 times. Should just appointed the attorney. I don't have the date of arraignment, but what I do have is the first notice of intent to invoke statutory defense filed by his attorney March 23rd of 22. And about 4 months later, 7/25 was the motion to dismiss. There's more than 4 months duration. There are 3, I don't know if I mentioned it, there are 3 Ninth Circuit cases coming out of Seattle District Court that hold that a request to proceed pro se coupled with a request for standby counsel is not unequivocal. It's a matter of law. U.S. versus Keinenberger, U.S. versus Salemo, U.S. versus Mendez Sanchez. And it's the request that must be equivocal, not the answer. And it's not whether the judge recites all the right things, it's whether the defendant.
But didn't the judge in this case say, I will not be appointing you standby counsel? Do you still want to represent yourself? And he said yes. So even though it may have been equivocal in that he expressed it as somewhat of a combined request, but when the judge made clear that she will not be granting A, it will only be B, and he said yes to B, isn't that unequivocal?
Don't believe so. And here's why.
Okay.
Because there's a whole nother topic that we really haven't broached, and that is, why is the defendant asking for pro se? And it's most often because they're not satisfied with what the defense attorney is doing. In this case, the defense attorney had agreed with the judge and with the Romanian interpreter. The Romanian and Moldovan was the same thing. And he was not supporting him in that. Mr. Sochirca was perseverating on the interpreter issue. There's 2 reasons. One doesn't show up in the record. The other is he didn't understand a lot of things, and he wanted someone who would explain them to him. The other reason why he was not happy with the public defender was because he was taking what Mr. Sochirca had said to the policeman at the moment, that I did it, yes, it was me. And he was running with that and he wasn't happy with that. So that was the motive. So you got to put it against that background. Again, there's more background, but that he wasn't smart enough to disclose on the record.
You're over your time. If you'd like to make a final statement.
Animals can be hard to. I witnessed myself. I could give you hypotheticals that I witnessed, but they don't stand still to be hit. Prosecutor said he should have used a club. I don't think so. That dog was not going to stand still for that.
Thank you.
Following these arguments, the court affirmed the trial court's decision. The court found Sochirca waived his right to counsel knowingly and voluntarily. They agreed that Sochirca had the right to kill Millie when he saw her attacking his chickens, but the law does not permit actions that will cause undue suffering, as committed in this crime. What do you think about the court's conclusions? Sochirca now faces up to 5 years in prison and a $10,000 fine. Is this a fair sentence? Let me know what you think in the comments below. And if you like this video, please hit subscribe for a new argument every week. Until next time.